Hello guys, welcome to my channel Lexora by Sami. Today we will discuss about pre-incorporation contract. Pre-incorporation means pre means before, incorporation means registration of the company. Before the registration of the company, there is certain contract. Today we will discuss about it. Before even starting the process of creating a company, several steps one may have to take before the actual registration of a company. Managers and promoters usually consider obtaining contracts or setting up business or finances that is vital for the future business. Who can enter into pre-incorporation contracts? Managers or the promoters. Pre-incorporation contract is an agreement that promoters enter into before the incorporation of the contract. Mainly, who enter into the pre-incorporation contract? The promoters of the company enter into the pre-incorporation of the contract. This type of contract is usually void as the company has not been registered yet, so it can be considered that the company does not exist yet. Still, promoters tend to arrange important factors like securing contract, hiring personnel, raising capital, leasing property, obtaining licenses, protecting intellectual property and commitments for the company to operate smoothly in future. Enforceability of pre-incorporation contract. We know that pre-incorporation contract is void, but the enforceability of pre-incorporation contract according to Specific Relief Act 1963, a pre-incorporation contract may be enforceable if the following conditions are fulfilled. Generally, pre-incorporation contract is void, but under the Specific Relief Act 1963, there are certain conditions. If that conditions are fulfilled, in that case only the pre-incorporation of contract is enforceable. First one is Section 15, Clause 8 of Specific Relief Act 1963. The company can enforce a pre-incorporation contract if the contract was made by promoters for the purpose of the company. It says that promoters made the contract pre-incorporation contract for the purpose of the company, not for personal. The company after incorporation accepts and communicates the acceptance of the contract. Section 19 clause of Specific Relief Act 1963, the opposite party to a contract may enforce the pre-incorporation contract against the company if the same conditions which are provided under Section 15 clause 8 of Specific Relief Act are fulfilled. Liability of promoters. The company is not bound by a pre-incorporation contract unless the conditions under Specific Relief Act are fulfilled. This is so because the company has no legal existence before incorporation and cannot authorize any person, even a promoter, to act on behalf of it. The promoters are liable for a contract that they enter before incorporation of a company unless there is a novation. Novation means that after incorporation, the company and the third party enter into a new contract. The contract is expressly made subject to incorporation and includes a clause excluding personal liability. Actually, guys, here we discuss that the liability of the promoters, as the company is not registered yet, so the company is not liable generally. So the promoters, as they are entered into the contract, they are liable. There are certain practical steps that the promoters can take to avoid the liability of the pre-incorporation contract. First one is the use of phrase. What phrase? Subject to incorporation in the contract. Avoid assuming personal liability unless necessary. After incorporation, the company should adopt or ratify the contract through a board resolution. After incorporation, the company enters into a new contract. Judicial interpretation of pre-incorporation contract. In the case of Kellner versus Buxton, it was held that if a company has not ratified a pre-incorporation contract, the promoters are personal liable. We know Section 15 Clause 8 of Specific Relief Act provides that if the company has not ratified, then the company is not liable for the pre-incorporation contract. In the case of Newborn versus Sensolid, in this case it was held that an unincorporated company cannot be a party to the contract. Therefore, the company is not liable. The promoters are personally liable. Basically, before incorporation, the company has no legal existence. That's why the company is not liable. Weavers Mills Limited, Rajapalayam versus Balkis Amal. In this case, it was held that after incorporation, if a company takes advantage of entering into a pre-incorporation contract, then it is deemed that company has ratified the contract.